We shall endeavor to start on time. Jean-Paul Mirat, I'm president of the French-speaking society. This is quite a recent appointment, and it is my honor to introduce our first prestige lecturer for this 2016 conference. I'm referring to Dr. Levallois, who is an ethicist and who manages a palliative care department in Cergy-Pontoise, and he's worked very hard on changes in the Leonetti law on palliative care at the end of life. As you can see, the title of this lecture is Developments over the past 10 years in this law, which for us is probably the law we apply most in our daily practice. So thank you very much for having agreed to come and give this lecture. You have 30 minutes. Thank you, sir. Thank you for having giving me a very tricky task. I had to replace Jean Leonetti, who was supposed to be here this morning, in fact, and he has a meeting at the Élysée Palace to talk about this very law. So you don't have Jean Leonetti before you, but Bernard DEVALOIS. I'm going to try to take stock of this situation. I'm speaking, of course, as a doctor. Of course, I have medical training, but I haven't worked in an operating theater for about 20 years now. So, of course, when one has medical training, that is valid for one's entire life. In fact, what I focus on is patient care when they reach the end of their life. For quite some time, I've been very interested in the issues raised by the 2005 law and what we may call the 2016 law. A brief reminder to begin. You may already know, but I'd like to focus on the main points in this law of 25. Unreasonable obstinacy has become illegal thanks to the 2005 law. Prevention, care, such medical acts should not go beyond what is deemed reasonable. The 2005 law tells us how we can try to understand unreasonable obstinacy. In fact, this law lays down a framework for unreasonable obstinacy. There are 3 dimensions. Usefulness. If there is no point, it's unreasonable. Things have to be proportionate. If things are disproportionate, they are not reasonable. And also, the purpose should not solely be to keep someone in life. So these are the 3 main thrusts that we have to think about on a daily basis when it comes to our daily ethics. We have to ensure that what we do as doctors is proportionate and useful and not designed solely to keep someone alive artificially. The 2005 law also says that, in fact, it's the patient. If the patient is able to do so, should be allowed to refuse treatment. In other words, even if we think something is reasonable, if the patient deems the treatment unreasonable, he's entitled to say no. The right to say no is not the right to choose, it's the right just to say no. The patient can refuse what we may think is reasonable. We can't propose something that is not reasonable, and the patient is entitled to think that a given treatment is not reasonable. When it comes to our daily practice, when a patient is not able himself or herself to say what he deems is best for him or her, then the decision should not be taken by just one doctor. There should be a multidisciplinary procedure. A team should meet to see what the patient would have wanted to do, even if he can't express this will now. Also, you can talk about a living will or a person of trust. Now let's look at the basic goals that I have just sketched out. Unreasonable obstination. And this was a mission I carried out in 2011 with the Observatory for End of Life. It's impossible to have a quantitative approach to unreasonable obstinacy. Nobody can say quantitatively whether such obstination has increased in France or not. Obviously, things shouldn't be unreasonable, but no one can actually assess the impact. If we have a qualitative approach, I questioned over 150 people from various walks of life who might be concerned, together with patients who use the health system. You can't say whether it's increased or diminished, but everyone agreed that there is a lot of excessive treatment in France. In other services, in geriatrics, cancer care, and many other hospital departments, there is a form of unreasonable obstinacy. It's like an iceberg. What you see most is what is covered in the media every 6 months or every year. We read about this or that doctor who is accused of going too far when it comes to medical treatment. I also tried to look at conflictual, unreasonable obstinacy. For example, the kind of behavior that is singled out by various entities or surveillance bodies, when people complain, for example. But that's peanuts. There's hardly anything at all. But when you talk with health workers, with nurses and users, they say, yes, there are very many situations indeed where there is overkill, so to speak, or rather excessive treatment designed just to keep someone alive. And then we have this notion of a person of trust. This is mentioned in the 2005 law. In the 2005 law, mention is made of the person designated by the patient, a person of trust. It's very difficult to understand what the part to be played by this person of trust should be. The patient is entitled to refuse treatment, so you have the impression that if the patient is no longer able to refuse, it's this person of trust who, by proxy, replaces what the patient might have said, representing the patient, and will choose for that patient. So who is this person of trust? A person of trust is just there to remind doctors what the patient's will might have been. Given the magnitude of the question, one shouldn't say, well, do you agree that we unplug the patient? No, that's not the kind of question you ask to the person of trust. The right question is, what do you think the patient would have decided? And possibly, what do you think? But under no circumstances should the person of trust give his or her agreement or refuse a given form of treatment. That's not the part to be played by the person of trust as defined in the law of 2005. Also, we need to look at the idea of a living will. Jean Leonetti said this is the weak link in this setup. The most optimistic assessments, and I'm not sure that they are actually accurate, say that 2% of patients have a living will. It may be fewer. It's mainly patients who suffer from chronic disease, who know exactly what's going to happen. For example, a lot of patients with these incurable diseases write a living will. But overall, they represent a tiny proportion. This is probably linked to two things. It's very difficult when you just have a blank page before you. In the 2005 law, it stated that one can write what one likes. So you're going to say, I don't want people to overtreat me. I don't want doctors to prolong medical treatment for no reason. But if you're ill, you don't really know what may befall you. So it's, well, wait and see what the 2016 law proposes. So it's hard to write something down on a blank page. Also, people say this serves no purpose because doctors don't have to take this into account, but they can take it into account. There's no obligation to actually implement a living will, and that's perhaps one of the factors which accounts for the fact that these are not very common. In 2008-2009, people started to look closer at the situation. Then you have the 2012 presidential campaign. François Hollande, who was going to be elected president of the Republic, made some commitments, and he proposed the 21st proposal, which you have before you here. The wording can be interpreted in different ways. At a minimum, this is ambivalent. It may be ambiguous. You can look up the meaning of that in your dictionary. It may, in fact, be almost misleading. What is medical assistance to finish life in a dignified manner? This is part of Didier Sicard's mission. This was covered in the report of the National Ethics Consultative Commission. And roughly speaking, I've just summed it up in this way, there are 4 legal possibilities when it comes to medical assistance to end one's life in a dignified fashion. First hypothesis, which many people have upheld, sort of Belgian or Benelux type depenalization, decriminalization. Here I put Belgium. It's Belgium and Luxembourg. In other words, this is lethal injection at the request of the patient. Then there's a second possibility, which is somewhat different. You have the Oregon type hypothesis. There are other American states that have adopted what we call the kill pill. In other words, you give a patient who meets certain conditions a pill with metoclopramide and barbiturates, and the patient swallows the pill. And then there's a third solution, which has been adopted in Switzerland. It's not actually decriminalization, it's just a loophole. And there's a form of tolerance to assistance to commit suicide. Volunteers provide assistance to the patient who wants to commit suicide. And then there's a fourth solution, which, as you know, was actually selected. The 3 others were eliminated by the legislators. This fourth possibility is sedation, deep, continuous, palliative sedation. That's one of the possible sedative practices. The idea is to enable the patient to go into a deep sleep. This cannot be reversed until such time as the patient dies. In other words, the patient sleeps because of the pharmacological agents until that patient dies. What predominated in the debate since this Proposal 21 is the search for a consensus. Society was very divided when it came to homosexual marriage, and medical assistance when it comes to ending one's life in a dignified fashion was deemed to require a consensus, and it was thought that it shouldn't lead to a divided society like in the former instance I've just mentioned. A deputy, 2 deputies, Claes and Leonetti, who were very familiar with bioethics, were called on and told, well, listen, find a solution which is acceptable for the majority of the opposition. That was the purpose. The idea was to work with them. There shouldn't be any left-right divide. The idea would be to find a general consensus within society, even if on either end there are some extremists which don't agree. So they wrote what we call a bill. Usually, laws are based on a bill submitted by government. This bill was written up by 2 MPs, 2 deputies. Of course, it's quite complex. According to French legislation, a law can only be adopted when it's been approved by both chambers, the National Assembly and the Senate. So it usually shuttles back and forth, and this gives rise to a degree of uncertainty. What we know today is that the National Assembly has voted in a first reading. The Senate looked at things, sent it back to the National Assembly, then it was sent back for a second reading to the Senate, which voted on a text which is quite different from the text approved by the National Assembly. So currently, according to the Constitution, there has to be a joint committee which will meet next week, in fact, on the 19th, and there'll be 7 senators, 7 MPs who meet together, and they'll compare the 2 texts in order to find a compromise solution. We don't really know, therefore, what's going to happen, and I'll try to explain this given the political context, which is a bit complicated at present. It's not very conducive to consensus. So a proposal was made by Claes and Leonetti. I'll sum it up. There are 3 main highlights which will help me in my lecture. Unreasonable obstinacy. The idea is to reinforce patients' rights. Patients' rights and not to undergo this unreasonable obstinacy. Also, there is this idea of medical assistance to finish one's life in a dignified way. Patients are entitled to have their pain and suffering mitigated, even in extreme situations. Third point, the idea is to have living wills. Well, the idea is to reinforce patients' rights so their living wills are respected. As you know, this is not always the case today. First topic, unreasonable obstinacy. It's important. We have to look at this very closely. There's a kind of redefinition of what the law calls unreasonable obstinacy. It's very important, this, because if the courts are to intervene, they're going to look at the law. So what does the Claes-Leonetti bill say? It says that these acts should not be continued over and beyond unreasonable obstinacy when they appear useless or disproportionate. In other words, unreasonable obstinacy is defined when it's useless or disproportionate. And this singles out certain situations. When the sole purpose is artificially to keep someone alive, then such care should be stopped. In the 2005 law, it says that certain acts should not be continued on the basis of unreasonable obstinacy. In the 2016 bill, it states that such acts designed solely to keep someone alive will be stopped or not undertaken. In other words, care, research, or prevention should not be continued if the sole purpose is to keep someone artificially alive. There has to be some other goal. It would be clear had the Senate not totally modified this definition. In this case, I've put you the new definition on the screen. I won't go into the details for lack of time. It's important to note that the definition provided by the Senate is different. One has the impression it's not just words. In fact, behind the words, there's some important things. What's important is that the Senate has used the verb may. If it's unreasonable, one can stop. And there's a second important point when it comes to the Senate's text. Usefulness is no longer a criterion. You have proportionality and the fact that the sole purpose is to keep someone alive. But this idea of usefulness has disappeared. In other words, this idea of futile has been removed. Also, you have the issue of the exact status of nutrition and artificially maintaining water balance. In the 2005 law, this was not stated. However, it appeared in the preamble, and certain amendments which excluded nutrition and water balance had been rejected. Then you have the Lambert case, the decision of the State Council. In the Lambert case, that clearly upholds this notion. The MPs considered that it was necessary to mention artificial nutrition and maintaining water balance constituted treatment. Like any form of treatment, this can be deemed futile. The Senate took up the matter when it comes to maintaining artificially the water balance. They say this is a form of care. Which is something different from just standard medical care, so this can be maintained up until the time of death. The MPs said that this should be viewed as just a form of medical care, but if this new text is adopted, it may change the situation quite radically. I'd like to refer you to an article that appeared recently in the press in October, an article I wrote on the fact that artificially maintaining water balance is not always a practice towards the end of life. In fact, this sometimes may be become an abusive kind of treatment. What is the ethical point of giving water to a patient who can't even eat if the patient doesn't get artificial feeding? It's a very artificial way of keeping a patient alive until that patient starves to death, in other words. So that strikes me as unreasonable obstinacy. The sole purpose of such treatment is to artificially keep the patient alive. Sedation, deep and continuous sedation was not banned, and in the future 2016 law, it's better provided for. If the patient continues to suffer, the suffering doesn't respond to treatment, and if the prognosis is poor in the long term, if the patient refuses to be artificially kept alive, for example, if the patient says, I don't want my artificial ventilation anymore, if the patient says, I want this to be stopped and I want to be put to sleep, and third, if the patient is not conscious, then you have to look at the 2010 implementing legislation. In the event of doubt, do not abstain from deep sedation. The problem is that the Senate in fact, modified this completely. In red, you have the changes introduced by the Senate, which did away with the fact that a patient who wants to stop being maintained artificially alive can receive deep sedation. And then there is a second case, if the patient is not conscious, and here I don't know what the senators really want us to do. For example, if a patient is not conscious, he can't say anything at all. If it is felt that the patient's suffering does not respond to treatment, that's the idea they have introduced, but that's very difficult to judge. Is this bill creating a right to sedation? As voted by the National Assembly, there is no creation of a right to sedation. It doesn't create such a right to sedation or euthanasia. It becomes a right sedation when the three conditions that I spelt out are met. This can be used in other cases, too. This is not limited to these instances, but it becomes a right for the patient if the symptoms don't respond to treatment, if there are only a few days of life left for that patient. If the patient decides to stop artificial ventilation, this becomes a right. And if the patient is not conscious and it is decided that the patient shouldn't continue receiving such care, then deep sedation is allowed. I'll speed up, says the speaker. It's very difficult to understand this further point. The 2016 law provides a framework for this practice and provides two sort of checks and balances in terms of medical assistance to end someone's life. This law would provide for two checks and balances. There would be a check before and a check afterwards. This is a very worthwhile idea. This was voted on by the MPs. Unfortunately, the senators rewrote this section. They blocked this check afterwards. The checking a posteriori, according to the senators, was subject to writing things down on in a registry, but they deleted all this. So there's no way you can check on the practice once whatever has been done has been done. This is one way of viewing matters, but I think it's very important to be able not to have something like the Federal Commission in Belgium. The idea is to be able to monitor these practices in order to check that practices are homogeneous around the country. Living wills. Okay, we've talked about deep continuous sedation, unreasonable obstinacy, living wills, which need to be better respected. If we can write a living will, but we wouldn't include or say the same thing if we're healthy and if we have a chronic disease, a fatal disease. If there is an emergency, the doctor has to implement a living will, and also there has to be a sort of a team discussion. Unfortunately, the Senate rewrote this section of the bill as well. Basically, they said that there aren't such constraints or provisions. Last slide. What impact will this have on our medical practice? Unreasonable obstinacy, I think, this issue will force we practitioners to think even more about unreasonable situations. And here I'd like to insist that's the purpose of my report to the observatory. We really have to take account not only of the views of doctors, the views of a multidisciplinary team. And personally, I'm very much in favor of having nurses and assistants. They need to make sure there isn't unreasonable obstinacy, that the patient isn't receiving unreasonable care under the circumstances. Quite frankly, it's extremely important to properly understand the idea of multidisciplinarity. In terms of sedation, I think this means that truly we have to think more about what we do with sedation. It shouldn't be an on-off mode, sedation or no sedation. What does this mean? What should one do in terms of sedation when it comes to accompanying a dying patient? I think we need to look at different types of sedation, and deep and continuous sedation, which is covered by the law, is just one of the 7 or 8 practices which we have identified in terms of sedation. Third point, it's important to understand the idea of a living will. Our citizens want doctors truly to take account of their will. Of course, one cannot deliberately cause death. That's in the penal code, the criminal code. That doesn't change. We don't have the right to do that. Second point, in the past, we had to mitigate suffering rather than just prolong life. That's very important. That was one of the points in the 2005 law. prior to 2005, we were obliged to maintain life at all costs. Otherwise, we could be taken to court. This situation was changed in 2005. The role of the doctor is not to prolong life at all costs, but to mitigate suffering when life cannot be prolonged. That won't change, and also there should be a collective ethical discussion and thought process. The idea is to realize that it's the patient who's the best person when it comes to deciding, but also we have to do what is best for the patient. One shouldn't mix up the patient's independence, confer that independence on a person of trust or a close family member. This is a point which I'm currently developing. What I focus on is this fixation on the patient's autonomy. Maybe we're overly influenced by Anglo-Saxon thought, where freedom is very important. We do as though the patient was able to decide for himself, but that patient cannot. This means that there is no right to terminal sedation. A patient can't claim the right that we sedate that patient in order that he die. There's an interesting article in the Journal of Critical Care in Belgium in 2014. The situation in France, however, is different from Belgium. Doctors there can sedate with a view to euthanasia. That is not something which is a topical issue today in France. So I don't know what's going to happen. Do I have a crystal ball? I hope the law will be adopted in 2016. I don't know what version will be adopted, that of the National Assembly or that of the Senate. Will there be a compromise solution? If the law isn't adopted, it's not a disaster because we have the 25 law, which remains valid. It means, however, that in a year or a year and a half, the issue will crop up again with the new presidential elections, and we may end up starting from scratch again. So to finish, this is something you're no doubt familiar with. This is a gentleman who's a bit of a couch potato, who's watching TV all day. It's great. He's very happy. And he says to his wife, well, above all, if one day I end up depending on a machine, please promise me that you'll unplug the machine. And so what does his wife do? She gets up and she pulls out the plug of the TV. Thank you very much for your attention.